Who wants to hear about UDRPs? Who wants to avoid UDRPs? We all want to avoid them. Next up, we have a legal panel. Karen? Oh, here you are. Hello. Don't play hide and go seek. Come on. Yeah, come on up. Yeah, Karen Bernstein. I don't know if we can introduce you. There is no introduction needed. But how many years have you been in the domain space?
2008, but that doesn't count me in 2001 when I got out of law school doing UDRPs.
Yeah, UDRPs in 2001. That's a tremendous amount of knowledge. Come on up, have a seat. Hope you're comfy. And Jim, there you are, Jim Davies. What year did you see your first UDRP?
No comment. Too long ago to remember.
We respect that. All right, I'll give you a microphone and bring up a second. So. Wonderful. All right, I will leave it to you, Karen.
Hi, everybody. I guess we only have one mic. Thanks for showing up.
You don't.
Oh,
yes.
good.
Bad news, I've got one too.
Uh-oh. So I guess we'll start with introductions, yeah? My name is Karen Bernstein. I'm based out of New York City. I have been, as you know, practicing a long time in this industry. I represent domain registries, registrars, domain name investors. I'm also a UDRP panelist with the forum in Minneapolis, Minnesota in the United States, and hopefully more. As you may know, in the United States, we are both barristers and solicitors. So we work on transactions and we also go to court, which is what I do. And I will leave it to my esteemed colleague here to introduce himself.
Thank you, Karen. My name is Jim Davies. I'm a UK solicitor, but I've also spent about 15 years working in Australia. So I've done domain name cases pretty much everywhere around the world, one way or another. UDRPs, AUDRPs, and court cases in Australia. A lot of DRSs here in the UK, and also some post DRS issues in the courts in the UK and also in the trademark registry in the UK. So sadly, I've been there and done it in a lot of places.
So I came up with this idea that, you know, both Jim and I have spoken about UDRPs for so long, it gets boring for us and it'll be boring for you. And instead we wanted to focus on really a domain investor viewpoint, because we, at least I represent both sides, the brand side and the domain investor side. And if I were to coin it in American terms, this is how we get them back. Representing domain investors that are either threatened with litigation over their domain names or are involved with UDRPs, and in some cases, court cases. And what Jim didn't mention to you is that he goes to court too. He is not just he's not a barrister, but apparently in the UK, I'll let him speak for himself, he does go to court. So what this is about is more about what strategies we've used with some anecdotal stories that we hope you find amusing. And bear in mind that these are circumstances that we're discussing where domain names have very high value. So obviously, you're not going to want to invest in legal fees for domain names that aren't of great value to you. So I will leave it to Jim to kick it off.
Well, thank you, Karen. One of the things I would say is I'm, in this context, envious of Karen in America in terms of post-dispute resolutions in court, because in America, as I understand it, you have specific statutory provision for this, Karen.
Yes, it's called the Anti-Cybersquatting Protection Act. We call it ACPA. And it's a mechanism where if you lose a UDRP, you have 10 days to appeal it. And it's not truly an appeal, it's a fresh approach by filing a lawsuit in federal court, basically asking for a reverse domain hijacking determination where a brand owner does not deserve to get the domain name. And as you also may know, is that 10-day window when you do get to go to court, it freezes the domain name from being transferred.
And that's important because, of course, quite often domain names can be quickly removed if the registrant or the complainant, whoever gets hold of it, has an opportunity to do so, and then you have even further difficulties in recovering them. Unlike America, the UK and other common law jurisdictions generally don't have a statutory provision like that. So I've been in court in Brisbane, in the Supreme Court in Queensland, where a complaint was brought by the registrant in time in that 10-day window. And that's not an easy thing necessarily to do if you're not aware of the rules. And in that case, and indeed in the UDRP, a jurisdictional choice is made at the beginning, which is either the jurisdiction that the registrant is living in or the jurisdiction that the registrar is located in. And in this case, it was the registrar. And so we had a complainant from New Jersey. We had our client was a company in the Isle of Man, and the case was being fought in Queensland in Australia. So I called it the Court of Mutual Inconvenience. And the first hurdle in those sorts of cases, and the same here in the UK, in fact, I think we've got Nick Wenburn-Smith with us here today from Nominet. He was actually involved in a post-DRS case in the High Court in the UK. And the first hurdle here and in Australia and indeed in Canada, where it has been decided, I think, is whether or not there is a dispute that can be brought, a controversy that the court will consider. We didn't get to the end of that debate in Queensland because the matter settled in the week before trial. So I still can't give you an answer, I'm afraid, for Australia. But that's why I say I'm envious of Karen that in the US you have a statutory provision, so there's no argument that there is an ability to have the policy decision reviewed. But another way of dealing with post-dispute cases or even during dispute cases is to look at whether or not the trademarks that the complainant is relying on are valid. And as Karen said, this is really only worth doing if the domain name has sufficient value, but we've certainly done that here in the UK in a case, a DRS case of Furnitureland, where the trademarks were bought by, it was an insolvent, very large sort of furniture retailer, and they bought all of the IP of their former competitors, but they forgot to buy the domain names. And so they had all the trademarks, but they didn't, Furniture Village this is, but they didn't have the domain name. So a well-known UK domainer acquired the domain name when it dropped, and then Furniture Village wanted it. And one of the things we did in that case was actually turn the guns back on them and commence trademark removal proceedings because they weren't, we said, using them. They'd bought them, but they weren't using them that brand wasn't being used in their shops. And to cut a long and fairly tedious story short, in the end, we won both the domain name case without the trademark case being decided, and then also had the trademarks removed in the High Court by somebody called an appointed person, who's the sort of second tier of appeal in the trademark registry. That's relatively cost effective compared to going to the High Court, but still, you would only do it if the domain name has significant value. Is that similar in the US, Karen?
Kind of, but more specifically, when you talk about multiple jurisdictions, I had a matter where someone had presumably not seen the notification of the UDRP. They were based in Pakistan, and so the mutual jurisdiction decided was the location of the registrar, which at the time is Unit Registry, which was in the Cayman Islands. So the client came to me and was a Pakistani citizen and wanted to bring, to stop the transfer of the domain name by going to the Cayman Islands. And we went to the Cayman Island court with a Cayman Island attorney to stop the other side from getting the domain name. There was a lot of difficulty in serving the the brand holder, I guess we'll talk about, who was in London. There was even a controversy over the fact that we had the package delivered of the paperwork and they had a CCTV picture and claimed they weren't served in time. And then eventually what they did was they went to the United States in Virginia, where VeriSign is located, that's .com, to bring a restraining order against my client to get the domain name back. And at that point, it was difficult to do so. And unfortunately, the client, we did send local attorneys there in Virginia, but unfortunately, they lost the restraining order and the domain name eventually transferred. But there are some other instances in U.S. courts where we haven't brought this type of ACPA case in the United States. In fact, we have a declaratory relief function in federal court. And so I had a very amusing but serious case involving SantaCon. Do any of you know what SantaCon is? Wow, I thought it was popular in the UK. So it's a worldwide phenomenon, participation where people dress up in Santa Claus outfits around Christmas time, and they do basically a pub crawl, and they get drunk, and they run around the streets. But originally it was based in Denmark. The concept was for charity, to give toys to children, and they went into a department store in Denmark and caused a ruckus by wearing Santa outfits. And if you fast forward another 10 or 15 years, in San Francisco, they started the tradition of SantaCon with a charitable element, and it was no pub crawl. It was just people running around in Santa Claus outfits, but it devolved over the years into these drunken pub crawls. And so clients of mine who were they actually organized pub crawls for all sorts of holidays like Halloween, St. Patrick's Day, and one of the events that they organize is SantaCon, and they have multiple domain names like, New York SantaCon, New Jersey Hoboken SantaCon, San Francisco SantaCon, and the organizers of the New York City SantaCon were able to get a trademark, I don't know how, in the United States for charitable fundraising, and they brought a domain name dispute against all of these domain names that my clients owned. And the client went to me and said, "What shall we do?" And I said, "We go to federal court and we ask for a declaratory relief. We ask for a declaratory judgment of no trademark infringement because no one owns SantaCon." SantaCon was actually created by a slightly anarchist in San Francisco who never intended it to be exclusive only to this trademark holder. And so we went to federal court and we were able to get them to settle quite favorably. My clients, I can't really speak in detail, but let me just say it was right before COVID, a lockdown, and we were able to settle the matter very favorably for my clients. So that's an example of what we can do in the United States when it comes to problems like that. Oh, but backing up, we went to federal court because once we went to federal court, we went back to the domain name dispute provider and said, this matter is in federal court. And as a result of the federal court action, there are so many other issues. We believe that this domain dispute does not belong, it is outside the scope of the UDRP because the UDRP is designed for straightforward cases of cyber squatting. And so the provider agreed, and it was never published. There was never a decision, but basically it went away. And then we went to federal court and it settled.
And just a slight tangent, but one thing we do, I'd say, I'll be nice to Nick here, have better in the UK than the US in this regard, or the UDRP in this regard, is that in the UK the DRS has an appeal process which the UDRP doesn't have, and so certainly if a domain is worth retaining and you are the subject of a DRS, a number of cases have been overturned on appeal in the DRS, because you get a 3-member panel in the same way that you can opt for in the UDRP, but it isn't default in the UDRP.
And does that cost money?
Nick gets a little bit of money out of it, but not a lot. I think it's about 3,000 filing fee plus VAT, as opposed to the 750 at the first instance. But you do get then a select 3-member panel who are purely doing appeals here. And for example, this year in the DRS appeal stage, for those of you involved in drop catching, there was quite a detailed analysis of what the panel felt was good practice or acceptable practice in drop catching in the UK domain name space. There's a 24-page judgment in the phoenixgroup.co.uk case. And to summarize, quite a lot of the business practice of people who are doing drop catching was considered to be lawful by the panel. So that's quite a useful decision to be applied generally, I'd suggest.
That's great. And also kind of slightly related is I was representing a client in federal court in Los Angeles. I used a local lawyer because I'm not admitted in California. But my client, having nothing to do with the UDRP, a lawsuit was brought for trademark infringement against multiple defendants, including my client, who at the time owned primp.com. And in fact, they filed a restraining order under seal, meaning it was secret. And they were a upstart clothing company, and there was counterfeiting involved, that is to the clothing, supposedly. And they went in and they went into a warehouse in secret at night with the police or the sheriff's department. Thank God they didn't go to my client's house because it was over a domain name. So the client got caught up in this lawsuit in federal court. And so we were able to go to the trademark office in the United States to try and cancel their trademark as a way of leverage to get them to settle. They eventually settled, and their lawyer, this is the plaintiff's lawyer, was so outrageous. She would hang up phone calls. She would hang up on me. She was erratic. We were able to show that she abused the federal court process enough that the judge ruled that she owed my client, I believe it was somewhere in around $50,000 US, and she couldn't afford it. And we had to have payment arrangements made through the court. So it isn't always through a UDRP, and I know the subject's not a UDRP, but that's another way that we use the trademark office to try and threaten or to get other brand holders that are trolling specifically generic names, to stop them from pursuing stealing domain names from investors.
So have we got a bit of time for questions?
Yeah.
Is there a microphone? Or?
Thank you, guys. What is the role of precedent here? So does that, because with domains and tech and everything, we're in a kind of a somewhat of a new age. Does precedent help? So where you had a certain judgment or whatever, you can use that in future cases?
The stated practice is it's not supposed to. The reality is that it does. So if you look in the domain name dispute process here in the UK, the DRS, the appeal panel decisions are often then applied in later cases. So there was one case that's, I think, the most cited one, verbatim.co.uk, and it's to do with the knowledge of the registrant had at the time of the alleged abusive behaviour. And that passage is quoted, I don't know how many times, but if you look at it in the search system at Nick's very helpful website there, you'll see it pop up in an awful lot of other cases. So yes, and
UDRP, yes, it's kind of same answer, which is that there is technically no precedent, so to speak, but there are certainly cases that are cited over and over and over again that are used as a basis for panelists' decisions. Yeah.
Any other questions? I have one. Regarding Web3 and everything coming along, there are so many people around it about, I'm sure there are quite a few people in this room, who might have gone on to the world of Web3 and literally got a truckload of brand names out there, because I'm not from the domain industry, but I can see some big brands are doing a terrible job in Web3 of doing anything, even bagsing and buying their own brands, never mind anything that might look by them if someone is typing something in incorrectly. What will happen going forward in the future in the next 5 to 10 years? Because surely, rather than paying your, I'm sure, not unconsiderable costs for yourselves, wouldn't it be just cheaper for the brands who are going after them in the future, when they finally wake up, to actually just say, rather than spending thousands, tens of thousands on legal proceedings, we'll just buy them? Because that's a huge wave coming.
Yes, absolutely. It's already here. Yes, brands are buying their names in Web3 names, but there are what I'll say mirroring companies, such as one of Lars' companies. I'm having a mental block about the name of the company. It's going to kill me. That are offering to play nice with ICANN, and they are subscribing to the UDRP with providers, because remember, those providers, they are arbitration and mediation providers. They're commercial enterprises, and if they're willing they're more than happy to take the money. And a lot of the Web3 brands are also offering blocking in Web3 for trademark. And what blocking is, if you're not familiar, is that if you go to, say, Coca-Cola whatever Web3, you're not going to be able to register.
So they're protected. Yeah.
Yeah. So there already are plans in place. I mean, if you're on in .eth and Ethereum, it depends on who the provider is, but the big players that like Unstoppable and those companies are already on board with providing a brand protection and offer UDRP.
Fantastic. Thank you.
Yeah.
Good to know. Any other questions? Yes. One more back. So we could do this just for the online audience. So.
Sure.
While each case might be a little bit different, is it true that if you go into one of these disputes from either side, you could be going into something that drags on for years? Like if you get federal court involved and appeals and things like that, could this go for years?
Well, the basic premise behind the dispute processes like the UDRP and the DRS and the AUDRP in Australia is to give you a much quicker and I was going to say dirtier, but that's not fair. But quicker and streamlined process to an outcome. As I said, the DRS has an appeal process, so that obviously is a second layer of time and investment. And certainly the Phoenix Group case, for example, the registrant there, he isn't with us here today. Lee Stenning had to invest quite a lot of time and time in me as well to get an outcome there that's actually of general value to the industry. And I think hats off to Lee for that, for those who are involved in drop catching. But yes, once you get into the court system, again, trademark removal can be dragged out by participants, but the court system is what it is, and it also is not what it used to be, in my experience, in terms of the volume of work that it's having to deal with and the cutbacks, certainly here in the UK. I used to moan about it when I was in Australia, and now I'm not moaning about Australia at all, now that I'm in the UK, in terms of the way that the courts are working or not working. So that part of it is both time consuming and expensive. So as Karen said on the top, it really has to be a domain that's worth the time and money to go into that process for that to happen. And that's certainly been my experience. The ones that I've gone to court for have been very high value domains.
Yeah, the only case that I'm aware of that has been appealed in the United States and successfully appealed was the pets.com case. And that was in the Ninth Circuit, I believe it was GoDaddy. So it was Arizona, and then it was appealed. And it was ultimately held that case, it really held that if you were the original registrant, you don't have to be the original registrant of the domain name to get the date of when you first started using the domain name. You can actually carry that over to subsequent owners of the domain names, but that is not the case in every circuit court in the United States. The Ninth Circuit is the only one. That's California, Arizona, Washington State, Hawaii. So the GoDaddies, the Enoms, the other registrars that are in the western part of the United States. If you're in the eastern part of the United States, they don't see it the same way. So it depends on where you're bringing a case in states.
Sorry, follow-up question. Do you find the judiciary judges, their level of technical literacy is okay, or they're kind of pretty much catching up to all this?
No, they seem to understand it just fine. I think there might be some judges, but go ahead, Jim.
Well, I remember it's a lot better than it was, because I remember one early case I asked the listing clerks for a tech-savvy judge, and then when we got into court, the judge stopped the barrister who was talking to say, "What's this at the top of this page?" And he was basically asking what an email header was.
Oh boy. Oh boy.
So we knew we were in for a bit of fun in that case, and a bit of a lottery situation there. So things have moved on from those days, and we have a decision here in the UK from back in the 1990s, I think, which is still floating around, an appeal court decision which has a most remarkable analysis of how it thinks people would be using the internet, which is still applicable as an authority because it's a court of appeal decision, but it requires users to be looking at the whois data, which of course you can't even do now.
Yeah,
But nobody ever really did anyway, apart from IP lawyers and domainers. So
yeah. I was going to say something and I think I forgot. You were talking about judges. There was a judge, but he really had a very good grasp of what was going on in New York Federal Court. John Berryhill and I represented a UK registrant. He was not a domainer over workbetter.com. And the other side had brought a restraining order, and they tried to. And we showed up in court in New York, and I was local counsel for John Berryhill. And the judge seemed to grasp everything and ruled in our favor and denied the restraining order. So
yeah, when they rule in your favor, they've really they understand things very well.
yeah, I like that concept.
Thank you both so much. Fabulous food for thought. And with that segue, we'd like to thank both of you and head out to lunch. But first, a proper round of applause